Live from Chattanooga, Tennessee, it's Nooganomics with David Tulis.
The skimming economy is something that we find often in operation in state governments. State governments around the country, in addition to the federal government, are part of this skimming economy. It's an economy that produces no value, but like the fee economy, say, by Securus here in Hamilton County, skimming fees off of communications between inmates and family members, or among inmates and family members, we have in Tennessee and its laws a method and a way of skimming assets from people who are innocent of any crime, people who have not been convicted of any crime, but who lose their cash, lose their valuables to the state, and have to sue. They have to sue and prove their innocence to get their looted material back, the looted assets back from the official buccaneers. And I'm referring to civil asset forfeiture, which is not a criminal asset. There's two classes of asset forfeiture. One is criminal and one is civil. The civil one is the form of thievery that you, my listener, are most likely to face. You, my listener, whether you're traveling on the highways of Tennessee or, as we're going to hear about from Braden Boucek, an outdoorsman. The outdoor thievery by the state against innocent parties is remarkable, and it has not received coverage. I follow this issue as closely as I can, and I'm hearing from an attorney about this hidden underworld of state thievery among private parties, fishermen with their bass boats, their SUVs, their trailers, their shotguns, all seized by the state for a pretext. And we're going to hear from Braden Boucek, who's an attorney at the Beacon Center in Nashville, about this process. We're going to shed some light on something which is a startling and shocking breach of constitutional propriety, where the state, by the power of statute, allows itself to poach, if you will, upon the private sector. Braden, how is it that the rural police departments, rural police forces, and rural game wardens are harassing innocent owners? What's the story?
Well, I mean, to begin with, game wardens already have inordinate authority that a lot of conventional law enforcement wouldn't already have, because game wardens have special authority to go onto land to protect wildlife species that ordinary law enforcement officers just wouldn't have going on private property. And so that gives them a wide-ranging mandate to begin with. But what can typically happen is, I mean, you've talked about the asset forfeiture, and the conventional scenario that we hear is the road stop, though it's far broader than that. But what you can see in a scenario in a rural county is we've got a game warden comes on your property and thinks you're hunting over a baited field or spotlighting deer or any of the issues that concerns game warden, and will confiscate as contraband basically anything of value, even things that are unrelated to the criminal offense or unrelated to the alleged perpetrator. So, for instance, you have somebody accused of spotlighting deer. Your buddy's guns, who may or may not have had anything to do with it, and then maybe they go to your house and take your bass boat. Those are all potential abuses that can happen in rural counties. And just the nature of rural county justice, which is just fundamentally different from the realities of what we're accustomed to seeing in an urban county, make it so there are far fewer checks to that when you actually get down to coming to it in court than you would see in a municipality.
Are these encroachments in the rural sectors more numerous than highway encroachments, or just less known? How would you evaluate?
It'd be tough to quantify it, and part of the reason why is because law enforcement agencies don't keep any of these records. And that's part of the reason why the recent study for the Institute of Justice, which is a 50-state comprehensive survey of asset forfeiture in the 50 states, gave Tennessee a D-, one of the lowest grades. And part of that scoring was based on the fact that there's virtually no records kept. So we really have no way of even ascertaining how much law enforcement agencies in Tennessee are collecting.
We're talking with Braden Boucek from the Beacon Center. That's at beacontn.org on the web. He is a Florida State graduate and a native Tennessean. I think you need to hear a little bit about who he is. He's a married man. He and his wife, Monica, have 2 children, ages 5. For 9 years in Memphis and in Nashville, and for 5 years he was a state of Tennessee prosecutor in the Attorney General's Criminal Division in Nashville, and then in Williamson County, which covers places such as Brentwood, south of Nashville. And he's fought in court as a prosecutor, organized crime and drug groups and individuals. But he got an offer from the Beacon Center, which desires to be more than just a watchdog, a government watchdog. I mean, to me, it seems like watchdogs have very limited value because they're just trying to stop government corruption. He has there's something more aggressive about him being engaged by the Beacon Center, and that is to prosecute civil cases, defending the marketplace, defending forgotten constitutional rights belonging to you, my listener, and also to defending defendants who are accused under laws that are abusive of constitutional liberties. Well, tell my listener, Braden Boucek, let's say my listener, my listener is not a rural guy. We are, after all, mostly in the city here in Chattanooga. He's traveling on business to Nashville. Okay. He goes through, he's on the highway tootling along. His wife is with him. And he's got $20,000 in cash in the car because he's going to an estate auction. All right, narrate what happens to my listener on his jaunt to Nashville.
Sure,
Braden.
Happy to do it. And you know, this can happen when you're driving. This happens in airports with a good deal of frequency too, which is something people don't consider because you do have a reduced expectation of privacy in airports, so it is easier for law enforcement agencies to search you. In fact, there's a case that the Institute for Justice is prosecuting right now that has to do with an airport stop. But the fundamentals of it are all going to be fairly alike. You get changed or whatever, and the officer has to search your car. You know, you're on your way to an estate sale, is what the scenario you've outlined, so you agree to do it, and the officer finds a large sum of cash currency in there. And the officer then says, well, you know, where'd this come from? I think this is drug proceeds. And, you know, even though he doesn't find any drugs in your car or any kind of contraband, you've got no kind of criminal history, they can take that money, confiscate it as contraband, and not arrest you, which you would, a lot of people would make the mistake in assuming is a prerequisite before they can actually start seizing your property. But the fact of the matter is the law enables law enforcement agencies to take the property without charging you, and in fact without ever charging you, let alone convicting you. And so, you know, the seizure is just step one. What happens next then is, you know, some time goes by and you say, I want my money back. They've never charged me. They're never going to charge me. And you decide that you're going to enter into the asset forfeiture process. And at that point in time, the traditional criminal justice process is stood on its head. At that point in time, the burden is now on you, the innocent party, to prove that the proceeds are not criminal in origin. Okay, and all the law enforcement agency has to prove is that it was by a preponderance of the doubt. That's a significantly lower burden. You, there will be no lawyer provided to you, and in fact, the reality of one of the reasons why this has such potential for abuse is that, and you know, I've had this conversation with friends of mine who are defense attorneys. You know, you'll get the person who will come into your office and say, "Hey, they took $4,000 of my money. I want it back. I can prove that it's not criminal." And the lawyer looks at you and says, "Well, you know, I'm going to charge you. It's going to cost me $3,500 to act on your behalf, maybe more." And most people just take their lumps and never bother challenging it. And that's corrosive to the legitimacy of the system. And that's one of the reasons why we think the system needs to be reformed. And I do want to take the moment to say, like, look, there is a place for asset forfeiture in the system. I mean, in a way, it's very fitting to take criminal proceeds and use them to fight the bad guys. So in theory, it can be a very good thing. But the problem is that it needs to be associated with criminal activity, and so if they're going to take it from the citizens, they need to be obliged to prove that it is criminal in origin, and we need to restore the basic constitutional process, which requires them to prove beyond a shadow of a doubt, beyond a reasonable doubt, that it is criminal in origin. And so that's why the reforms that we're championing are mainly along the lines of it needs to be associated with a criminal conviction. The burden is on the state to prove it. And then the other thing that we really push for is that when the state takes the funds, rather than those funds going into the general pot or being going to the pot for the particular local law enforcement agency, it needs to go into the state's general fund. And so what a lot of people don't understand is that asset forfeiture goes to directly fund the law enforcement agency that seizes it. And, that leads to all kinds of perverse incentives and potential for abuse because it is essentially policing for profit. I mean, anybody out there who's doing their job understands that when your salary and your funding is tied to particular activity, then you're going to make decisions based on that. And that's not to call into question the judgment of any of our highly competent law enforcement agencies. It's just a natural thing to do. And what we're advocating for then is when those proceeds are seized, they go into the state's general fund, and the law enforcement agencies in turn get funded through the regular process of legislative funding, which we think would remove the nexus between the seizure itself and the incentive to seize because it becomes self-funding.
We're talking with Braden Boucek from the Beacon Center in Nashville. He's an attorney, a former federal and state prosecutor, and we'll hear a little bit more about some of the cases that the Beacon Center is pushing. But in what you're talking about here, Braden, regarding civil asset forfeiture, are you proposing changes in the statute? Is that it? And how is that? So this is a political effort that's underway to get the legislature to revise the statute. What's happening there in this effort?
That's correct. So, I'm the lawyer, but we have a policy side too, and they're largely responsible for pushing things like school choice and lowering your taxes. But one of the issues that we're doing in conjunction with the ACLU is we're pushing for asset forfeiture reform. And what the reform looks like is that we are pushing for civil asset forfeiture to become criminal asset forfeiture. So that is, it goes hand in hand with the criminal prosecution. The state would have to prove your guilt beyond a reasonable doubt. And then we're also pushing for those funds to get allocated to the state's general fund rather than the particular law enforcement agency.
Well, are you essentially, Braden, are you essentially
responsible for the seizure? So there is a legislative push that our organization is doing on the policy side, with groups like the ACLU, which strikes a lot of people as odd bedfellows, but we're aligned with liberty more than we're aligned with anything else, and we'll work with anybody to get us there.
Well, so essentially, what you're saying on the policy side, Braden Boucek of the Beacon Center, is that you're pushing for effectively abolition of civil asset forfeiture, pushing all asset forfeiture proceedings by the state against a private party into the criminal side. There has to be a criminal case, a criminal accusation.
Yeah, well, you've accurately described it, though I would push back a little bit on the characterization of this as abolition. I mean, I've done criminal asset forfeiture. Most prosecutors who've done any amount of drug work have done criminal asset forfeiture. So it doesn't mean you can't keep the criminal proceeds. It doesn't. It just means that it's got to go through the regular, ordinary process that we associate with criminal proceedings. And really, if these proceeds are criminally derived, such that it's appropriate for you to take them in the first place, it's not that big of a burden to put it into your indictment, submit it to a grand jury, add it to the charge, and at that point in time, the person either pleads guilty to it or it's resolved by a jury at a trial. But it doesn't, in theory, take away from law enforcement's ability to take anything that they wouldn't ordinarily be taking, as long as it is, in fact, criminal proceeds. It just puts the onus back on them to prove that it is criminal proceeds.
Braden, my listener has a question, and I'm here in the media, right? The word media means between. I'm between you and my listener, and so the listener is sort of asking me by, I guess, telepathy, to ask this question. What does he need to know about the traffic stop? That's what we hear about these cases, including the one that the Institute for Justice is defending on the man on the, I think it was a train, the young man on the train, or was the airplane. What does he need to know on the side of the street? What he wants, I think he needs just to say no. So what does just saying no mean for granting permission to search? Can give a sketch, give a quick sketch as to what he needs to say and no and why.
Well, as to what he's supposed to do, that's a fact-specific scenario. But as far as what your rights are you have an unequivocal right to refuse to consent a search of your car. That's not to say you should do it. There may be good reasons why you should do it, but you do have the right to do it, even if the officer is asking you questions in such a way that makes you feel like you probably should say yes.
Well, hold on a second, Braden. Hold on. Why would back up here? You're immediately conceding something here. Why would the listener? You sound like, well, maybe you should grant consent. Why should the listener ever grant consent, Braden Boucek? Why are you conceding that?
Well, I mean, that would just be a particular person in a particular scenario who thinks that they've got a reason why they might want to do it. And maybe it's because I don't know. Maybe there's a kidnapper in the car. I don't know. I'm just saying there may be situations where it's in that person's interest to exercise their right to give consent to a law enforcement officer.
Well,
I mean, I think the general scenario you're outlining.
I'm not with you on that one.
Cash proceeds that are not criminally derived in the car. There probably is no reason to grant consent, but you do have to know that if the officer has probable cause to search your car independent of the consent,
right,
then they can still search it
right,
regardless of whether or not you consent.
It seems like we should be telling the listener to say no.
That's basically what your rights are in that situation.
Okay. Well, you're kind of offering a gray analysis here rather than a stark black and white one. My argument would be the listener should never say yes when requested for a grant to search. He may be waylaid 20 minutes or so. They may try to bring a dog in, but
though I will tell you that they can, if the reason why they've stopped you is for speeding, okay, they cannot detain you any longer than it takes to write you that speeding ticket and check your ID. Like they can't just keep you for 20 minutes to an hour to get a dog in.
Okay.
To come up with an additional
they can't
probable
stress
cause
the pretext.
to do it. They're limited by the purposes of that stop.
Okay.
Now, if they can get a dog in there in that amount of time, then that's permissible. But they can't keep you just for the purposes. That's an unlawful detention. Okay,
so all right, so now, but granting, I think that the main question that he wants to know about is why do I say no? What can I say when I'm saying no? How do I say no? What's the best way to say no, Braden Boucek? And
It's funny you mentioned that. I remember when I was in law school, my criminal law professor saying, "Look, if I had nothing in my car, not one single thing, and nothing to hide, I'd always say no." And he's like,
good for him.
Yeah, he said there's just no reason to say no, say yes. And the way he told me, I remember him saying it, is he said, I apologize, officer, but I just I can't see the point in consenting to a search, the results of which I don't know, or I can't. What did he say? I can't see the point in agreeing to a search, the results of which you can't guarantee me the results. So it was something along those lines, but It was basically a deferential way of saying, I apologize, but I don't know where you're going with this, so I'm not going to agree to it.
Right, and
you should always be respectful. I mean, there's no reason not to be respectful. You don't want to heighten the emotional stakes of a law enforcement encounter in any event.
All right, so tell us briefly. Well, actually, we just have a minute here. I want to mention we're talking with Braden Boucek, who's an attorney at the Beacon Center, which has kind of gone on the warpath. The Beacon Center is going on the warpath on your behalf, you, my listeners' behalf. It is there looking for cases, and we'll hear a little bit more from Braden about what you can do to help this effort to find a plaintiff or a defendant involved in a civil asset forfeiture case who needs some help. And the Braden works for the plaintiff or for the defendant pro bono. That means without charge. Pro bono is Latin, which means for good. Bono is good. He's working for the innocent party for good. And you, my listener, I know you care about these things. I know that you have means also. And so the Beacon Center at beacontn.org is looking for support. It's looking for cases. There's a way you can identify parties who might need the help of Braden Boucek and others at the Beacon Center. My name is David Tulis. We're here at AM 1240 Hot News Talk Radio. in Chattanooga and beyond. We cover local economy and the free market, and we make a wonderful and whimsically weak argument, and that is love your neighbor and buy local. We're brought to you here by Advantage Printing over on Brainerd Road. Ellen does a tremendous job for me. He does printing for our radio station. He also does mail services for a homeschool newsletter, of which I'm the editor, and that's called Esprit. Advantage Printing is always to my advantage, and I know that he can be to your advantage too. You, our listener here at the All Talk station, the Sean Hannity station, the Colin Cowherd station in Chattanooga and beyond. Advantage Printing, again, is at 629-1800. That's 629-1800. I've got some things I want you to hear. I want you to remember, support my advertisers and you support me. If you like David Tulis, if you like Sean Hannity, if you like Keon Rose with Clutch, the sports show, and other fine things here, be a sponsor and support our advertisers. Hang on, I've got something I want you to hear. Hang on. Hey, we're talking with a man who has, you might say, repented. He's repented of being a federal prosecutor, though he did nothing evil in that office, I'm sure, and a state prosecutor. His name is Braden Boucek, and he represents the Beacon Center in Nashville, which is a free market-oriented government watchdog type organization that is funded by charitable donations of people like you, my listener. The man who doesn't really love liberty that much, but you're starting to love it. You're starting to see that there's something here that really is part of your profit, part of your gain, part of your inheritance for your children. And if you have liberty, well, maybe life is a bit more exciting than it is under the gray drudgery of our modern state and its welfare and surveillance system. Braden Boucek he's a married man. He and his wife, Monica, have 2 children. They live south of Nashville. And he's a native Tennessean, and you can find out more about him at beacontn.org. That's beacontn.org, and he's telling us about the whole strip mining of local economy and the state economy by what's called civil asset forfeiture. Braden, what's the Beacon Center doing and saying about civil asset forfeiture?
Well, civil asset forfeiture is the practice where law enforcement officers take property that's ostensibly criminally derived, but even though they never charge you or let alone convict you, they keep the property, and if you want to get it back, then you're the one that has to hire a lawyer and prove that the proceeds are in fact criminally or not criminally derived. And we think they've got that exactly backwards, that if they're going to take property, it's the same as taking your liberty. They need to treat it like a crime. There needs to be a charge, and they need to prove it beyond a reasonable doubt. And then after those proceeds are taken, they need to go to the state's general fund. Law enforcement agencies shouldn't be self-funding based on the property that they seize. So, that's in a nutshell the abuse that we see potentially arising from the current structure, and the remedy that we see. Now, the remedy that I've just outlined is very much the policy side. And one of the things that we're doing at Beacon is we've got our policy side, which is advancing legislative change, but they've also got me, who is there to litigate on behalf of the same causes. So what that would look like in the asset forfeiture context is that if we could find the correct asset forfeiture case, we would be interested in representing that person, and representing that person and claiming that their constitutional rights have been deprived by an unconstitutional seizure.
Let's talk about that just for a second. Braden, let me ask you about that.
We'd like to put the whole process on trial, so to speak.
Let me ask you this. What does my listener, maybe the man you're looking for, what are the kind of the requirements for him if he is going to be assisted by your pro bono efforts through Beacon Center? What are the characteristics of the defendant or the plaintiff in this matter?
Yeah, so we need somebody that obviously, number one, has been a victim of asset forfeiture. So you've had cash or property seized by law enforcement, and you've never been charged, and you've never been convicted of that crime. Secondly, the way the law is now is that you have to prove that it is not criminally derived. So we need somebody that can prove that these proceeds are not criminally derived. It's the scenario you've outlined. It comes from an estate sale, or maybe you won it in a lottery, or you won it in a casino. That's why you're traveling with a large amount of cash, whatever it is. But part of our part of what we're doing is we need a good story. So we're not going to represent the drug dealer. We're going to represent somebody that can show that these proceeds are genuinely legitimate proceeds that have been swiped. But the good news to all of it is, we represent people free of charge. It's pro bono. And we subside on the donation of our listeners and contributors. And that gives us the ability to not just get worn down by the system and kind of fold because it's just getting too expensive to fight it. So that gives us, in the potential plaintiffs, that levels the playing field between us and the governmental agency. So if you are that person, number one, that you think that you are a victim of asset forfeiture, you can prove that the proceeds are not criminal in origin. You can go to our website, that's beacontn.org, and there's a tab there where you can click on and submit your case. And if we're interested, we'll get back to you on that sort of thing. The other thing is, if you're just concerned about this, we subsist entirely on the contributions of people who are concerned about the cause of liberty. So, you can also make a donation. And we'll take any donations we can get, but naturally, the larger the donation, the bigger of a force we can have. I mean, ultimately, the vision that we have for Beacon is that we are a significantly sized law firm in service of liberty in the state, and that we are, I'll use the word notorious enough, that every governmental agency in the state is thinking in the back of their minds, if I do this action, is Beacon going to sue me? And how will I defend it? And I think that if we've got that mentality out there in our state government officials, then the cause of liberty will be significantly advanced right there, because there'll be plenty of actions that are not going to get taken because they know that they'll be accountable for it. And I can't tell you the number of times I've interviewed with people where it is just manifestly obvious to me that they're getting run over by a particular governmental agency, and that would have never happened. What the government agency is counting on is that this will never see the light of day,
right? Because
this person's just going to surrender rather than go through the cost and hassle of fighting this.
Well, listen, now we're talking with Braden Boucek. You're my listener. There's something else that Braden's working on, and he's looking for someone. Now pay attention, because it may be you, or you may know the party who could be a litigant in another issue, and that is the one of occupational licensure. Which particular area of occupational licensing do you desire to litigate, Braden Boucek of the Beacon Center?
So occupational licensure means that you have to have a license to work. Traditionally that meant if you're a dentist or a lawyer or a doctor, you needed a license to work. In 1950, that generally was who had to have a license. Nowadays, by some estimates, 1/4 of professions need a license to work. And that it predominantly falls upon lower income professions. So it really is tantamount to a poor tax. And I'll tell all your listeners out there, the next time you go get your hair cut, ask your barber what they had to go through to get their barber's license. And it will shock you how much expense, time, and effort they had to go through to get their barber's license. So Tennessee is actually 13th among the 50 states in the sheer number of occupational licensures for low-income professions. It's anything from manicurist to teeth whitener. But the most egregious one that we found is in Tennessee is one of 5 states where you've got to have a license to wash hair. And I said that correctly. Just to wash hair in this state, the simple act of applying water and shampoo to the scalp, you have to have a license to do it. And you can be fined very seriously if you commit the offense of unlicensed hair washing. It is in fact a Class B misdemeanor, punishable by up to 6 months in prison, to practice any form of cosmetology without a license. And make no mistake about it, the state is serious about enforcing this. I do open records requests on this. I keep very careful tabs of it. And I've got a stack probably about 8 inches high of people in the recent past who've been cited for unlicensed hair washing. There are investigators that investigate this. The state employs attorneys that essentially prosecute these offenses. And we cannot wait to find a shampooer that is willing to challenge this. So we have interviewed any number of people, but we're still looking for the exact right, perfect plaintiff to go challenge basically the right to work in this state to pursue a lawful occupation. We think that is a constitutional right.
I agree with you, and I think the listener has the vague suspicion that you're right. What are the characteristics of this ideal plaintiff? You say you've talked with several hair-washing prospective plaintiffs, but you haven't yet found the right one. What's wrong with the ones you've talked to, and what is the key point of the party who could be the plaintiff or the defendant in a Beacon Center case against this travesty?
So, we'd like somebody with a good life story, somebody that's overcome adversity, and somebody for whom the ability to wash hair would make a material difference in their circumstance. Okay. And that person needs to be somebody that is willing to endure a certain amount of media scrutiny and a certain amount of hassle for dealing with the litigation. It also needs to be somebody, that can withstand a certain degree of scrutiny, in terms of their background. So, it needs to not be an issue if the state decides to audit your taxes or something like that. All those kind of things need to be in order for this person to be able to be a palatable plaintiff.
You're suggesting that there's blowback by the state in other areas of a plaintiff or someone who's attacking a part of the licensing structure, right?
I don't know, because we never pursued that kind of case, but I'm concerned. I want to represent a person that can go all in on this thing, and I don't want somebody to be in the middle of this thing and realize that they've gotten themselves into a mess and regret that they've done it. What I want somebody who's worked hard their whole life, who's overcome adversity, and who wants to just go make an honest living by washing hair, and it'll make a big difference for them and their family, and it'll materially alter their circumstances. And somebody who really can't afford to pay for an additional 3 to 6 months of schooling just to do something that everybody does virtually every morning, which is apply soap to your scalp and then rinse it out.
Now, Beacon Center has taken an interest in another free market issue, and that is the liberty of homeowners in the Nashville area, subject to the Nashville ordinance, to rent out through the Airbnb sharing network rooms in their houses or apartments for short term. What is happening there, Braden? And why does this matter to my listener?
So we actually already do represent a couple in a lawsuit against Nashville, and they're a young couple. He's a singer-songwriter, of course, it's Nashville, and she kind of works from the home as a graphic designer, but they travel when the husband is on the road. His name's PJ Anderson, very talented young musician, but they figured a year or so ago that they could, while they're out of the house, it just made sense to rent on Airbnb. And they're a young couple, so money's tight. They've got 2 young kids, a third on the way, and Airbnb has just materially altered their financial picture. I mean, it means they have money to invest in their private business. They don't have to worry about their mortgage anymore. They can save for retirement, their kids' education, on and on. It's just really been a boon for them. And then there really was no problem. They never had a complaint about their property or the way they were doing their Airbnb. And the city, effective in the middle of this year, decided to start regulating it. And one of the things they did was put a cap on the number of non-owner occupied Airbnbs. So, and the cap is at 3% per neighborhood. So they were doing it, they were fine. And then Rachel, the wife, got a job prospect in Chicago. Well, PJ is going to be returning to Nashville. He wants to keep recording here. They want to keep the house. They actually want to retire here, but they can't afford to keep the house if they can't do Airbnb. So they went to go get their permit converted to a non-owner occupied, but too late. The cap had been hit. And those caps, they're not based on anything other than first come, first serve. And the decks never shuffle. You can essentially keep your permit in perpetuity. So all of a sudden they're forced into this situation where they had to decide, do we want to keep the home that we love, or do we want to pursue this job opportunity? These are family decisions. I mean, this is finances, career, home, and all of a sudden you've got Nashville pulling up a chair at this kitchen table discussion and weighing in on the decision. And I mean, we live in a country right now where the Supreme Court has said what you do in your bedrooms is nobody else's business. So my question is, why is it anybody's business what you do with your bedrooms? Right?
Right, exactly.
And I mean, if you think about it, until very recently, the notion that the government had anything to say about who you let into your home is ludicrous. Nobody would have ever said the government gets a say in who I let stay over, if it's a friend, a family, or just a transient. But the Airbnb has brought this issue to the fore, and my clients have really been harmed by it. And the reason why people need to care is because this is bigger than just an Airbnb right to use your home as you see fit kind of issue, even though that's important. It's important because the sharing economy has made this whole new class of entrepreneurs, right? This is going to keep happening as the internet and the sharing economy opens up new forms and new ways of doing business. And governments are struggling as to how to address these. They want to put it in one of two old boxes. Either it's a business or it's not a business. And I would submit to you that sharing economy doesn't fit into the old boxes, right? I mean, you're not an employee of Uber. You do Uber an hour a day. Maybe you don't do it for 3 weeks. Then you do it for, 3 straight weeks. It just doesn't fit into the traditional role models. And so governments need to quit trying to apply mismatched, outdated New Deal regulations to something that is new. And they need to stay their hand, because they risk quashing these new industries before they even get off the ground. I mean, if you just treat Uber like a cab, you've destroyed Uber. And if you just treat Airbnb like a hotel, you've destroyed hotels, or you've destroyed Airbnb. So you need to give these things a little bit of life to breathe, because this is what the new economy is going to be. And all the wonderful things that are going to come with a new and dynamic industry are going to follow if we let it.
Is it possible that the digital economy represented by Uber, as you mentioned, and Airbnb will push back the claims of the modern state, whose services are seemingly ever less in demand and serve ever less a general public interest, or are we going to see an advance of the state challenging the marketplace, challenging the sharing economy?
Well, those are the stakes. I mean, that, and it's wonderful. What is so gratifying about this Airbnb case, as I've interviewed innumerable amount of plaintiffs, and the vast majority of them are, as you expect, they're young people. They live in these really urban areas of town. So they're not people that you would traditionally associate with the free market, right? I mean, most of these people are wearing really blue jeans and hipster glasses, and, they're those kind of people. And, you sit down with them and they start talking about the law. And the first thing they'll say is, I don't understand why there's a law in the first place. This was working great. It was win-win. I was making money. The people who came were enjoying Nashville. They were introducing money to the local economy. The regulation is stifling new people from joining it. People will say, the only people who are going to do this are the people that are connected enough to have lawyers and accountants, or they're people that are just going to do essentially an Airbnb black market and flaunt the law. But the regular little guy, law-abiding people aren't going to want to do it. And I just hear this time and time again, and they're essentially, you can watch the course of the conversation, these light bulbs going on, and these people developing this raging appreciation for entrepreneurship and capitalism. And there's this young generation of 20-somethings that if you're my age, I'm 40, the opportunity to become a businessman really never presented itself. But the sharing economy makes it so easy to become an entrepreneur that it is making a whole new class of capitalists. And you just want them to keep connecting the dots and saying, why don't we challenge the orthodoxy in some of these other industries as well? But the light bulb goes on for a lot of people. I sort of call Uber and Airbnb gateway drugs to capitalism, because that's what they are.
Well, your goal at Beacon Center as a staff attorney, your goal is to increase liberty. So you're trying to regain lost liberties under the legacy state economy, and you're also trying to protect you might say liberties that are emerging in new form in the sharing economy. So what about in this older the effort under occupational licensing? Those are older callings, right? These are callings that have old names.
Absolutely.
And you're trying to give them room to breathe and encourage people to enter them if they want to, and not have to deal with the state at all. That's the goal, is to not have a state encounter for what is an innocent occupation of, I would say, of right.
Right. And I mean, distilled to its essence, what we're talking about is the right to pursue a lawful occupation. That's what it is.
A lawful and innocent occupation.
A lawful, where there's just zero state interest in protecting the public health and safety, which is the generally stated rationale for why there needs to be a license. But that doesn't exist with hair braiding. It doesn't exist with teeth whitening, eyebrow threading. I mean, some states, Tennessee's not one of them, some states require you to have a license to be a florist or a horse masseuse. The most egregious one in Tennessee that I'm familiar with is the shampooer. But, we live in a state, the state of the Constitution today is such that you've got a constitutional right to burn a flag, you've got a constitutional right to get an abortion, but you don't have a constitutional right to pursue a lawful occupation. And I just think that is frankly nuts.
Well, tell my listener, Braden Boucek, how he can contact you or the Beacon Center if he has a possible case or a possible plaintiff, right quick.
So we've got to go to our website. It's beacontn.org, and we've got a tab on there for cases and case submissions. And we take cases, case proposals online. There's no guarantee that we'll take them, but we'll evaluate them and give you feedback. But this is the vast majority of the ways that we're going to get their cases is when people come and find us. And unfortunately, we're only allowed to take a few of them. When you offer free legal services, you're very limited. But we are funded through the generous contributions of our listeners and donors. So if this is a cause that you believe in, litigating for liberty, please, we accept all. We're grateful for all contributions.
And this is David Tulis. Braden, thanks so much.
Thank you. Anytime, David.